The next matter I have is Kyle Mendoza Lopez and Juanita K. Vasquez friend. The cause number there is 20-3502-08. Ms. Gilmore represents Ms. Is it Vasquez?
Friend.
Vasquez. Okay, Ms. Vasquez. And
Sorry, Your Honor, friend. Her name's Juanita Friend.
Friend. Okay, great. Thank you. All right. So Ms. Friend is on the line today, I see. And then
yes, ma'am.
And okay, great. And then is Kyle Lopez on the line this morning? Kyle Lopez?
Yes, Your Honor, I'm here.
Okay, welcome to you, Mr. Lopez. We are here today on Mr. Lopez's motion for contempt related to the son's bank account, a visitation on the weekend of the 8th and through the 10th of September, and decision-making regarding preschool. So I've read over the parties' pleadings. So Mr. Lopez, if you want to go forward and just go ahead and argue your points, and I'll hear from you, then I'll hear from Ms. Gilmore.
So this has been going on for 3 years now. I'm here representing myself because this is an easy matter. In our parenting plan, there's 3 main things that I'm here for today. One of them is the bank account situation. In our parenting plan, it states that I'm supposed to be on all decision making and have access to all information, and I simply don't. My son's tribal, and I'm not even able to call his tribe and get resources and help for him. Juanita has called the tribe and told them specifically to not let me call or receive any type of information regarding my son.
I apologize for interrupting, but I do have to object. I don't believe that was contained with the materials, and I don't think that's factually accurate.
So let me ask Mr. Lopez, the 3 items that at least I saw in your motion for contempt was one that you didn't have access to the son's bank account, that you're asking for contempt on the missed visitation, and that 3 decision making regarding preschool. So those are the 3 bases.
Yes.
Is that accurate?
Yes.
Okay. And then if you could help me on the access to your son's bank account in the parenting plan that was signed on December 15, 2022, can you show me where it relates or addresses the bank account information?
I'm trying to find our parenting plan.
Yeah, I found.
Sorry, what's that?
I found one provision that reads, it says, access to information regarding the child's GWE payments. It says, mother shall sign any documentation necessary to add the father as a person who has access information regarding Cowlitz Indian tribal benefits and daycare benefits, healthcare, and GWE payments on behalf of the child. The parties agree that the GWE shall continue to be directly deposited into the child's Red Canoe savings account 5465. So that's the one provision that I saw that seemed to relate to the bank account. So is that the provision that you're relying upon?
Yeah, I'm supposed to have access to that bank account, and I attached an email or a attachment, Exhibit A, where it simply says that I don't have any access. I don't have any reason to pull out money or mess with it because I have reason to believe that it's not able to be pulled out from or withdrawn, only deposit into that account, as that's my son's money. And I can't even call to request information if he had gotten a GWE or if that money is still there or anything regarding the GWE or his money in his savings.
Thank you. Can I ask you, you said there's an Exhibit A attached to your motion, is that correct?
Yes, it's the Red Canoe email. It says Kyle Lopez has no access to any accounts with Mauricio Friend Lopez.
So I'm looking at your motion for order to show cause that was filed on October 4th. That's the document that says that has Exhibit A attached?
Yes.
So on my motion, the motion that's filed with the court, there's 5 pages and there's no Exhibit A. So it's just all the the motion itself, motion for a contempt hearing. So there's no exhibit A attached to it. Might it be on a different document?
No, it should be in that same document.
And I can kind of
'Cause
chime.
Ms. Gilmore, you were saying?
Sorry, I was gonna chime in. I also was similarly confused. I received some materials via email. It was like testimony in the body of the email. I didn't actually review it until yesterday evening when I was preparing for today. So I didn't see anything in Odyssey either. So I don't think any of his responsive materials actually got filed with the court. But I don't know. I wasn't sure what he actually did.
Yeah,
So you-
Your Honor, I have 3 attachments that I attached to it.
Okay, and were those attachments that Ms. Gilmore said she received some information yesterday or before, and then she was looking over that. Is that the information you're talking about? Because it sounds like you're
Yes.
referencing.
So the 3.
Sorry, it's the Zoom delay thing. Go ahead and finish, Mr. Lopez.
I have 3 attachments to it. One's for the visitation and her not accommodating meeting me halfway with my work schedule, and then the second one is the police report of when the officer had to call them and ask what was going on for not coming to pick up and what the reason for was. And then the third one was the bank account email.
Okay, and those 3 documents, did you submit those to the court, and when?
I was told to give it to her attorney.
Okay, all right, so you gave it to the attorney, but you didn't file it with the court, correct?
Correct.
Okay, so that puts me at somewhat of a disadvantage in that both you and Ms. Gilmore have seen the documents. I haven't seen the documents. I'm assuming that it's something that you would like me to see those documents, and so if that's the case, then I think we should probably, I would entertain a motion to continue the matter so that I can review those documents and we can all be on the same page.
Yes, Your Honor, I'm fine with that.
Okay. So what that means, Mr. Lopez, those documents that you gave to Ms. Gilmore, you'd need to file those with the court also, and that would probably mean we'd need to set this over probably 2 weeks, because Ms. Gilmore's client would have an opportunity to reply to what you had filed. So today being the 21st, we'd be looking at December 5th, and I'll just see if everyone's available on December 5th.
I'm in trial in Clark County that day. I have a 2-day trial.
Okay.
But the next week, I'm available the next week. I have readiness, but that's
On the
after.
12th.
Yeah.
Okay. Mr. Lopez, if you can get those documents into us, and then would you be available on December 12th at 9 a.m.? Looks like you're still muted.
Sorry, Your Honor. I'll be working 6 a.m. to 6 p.m. and I don't get breaks at my job, and we're very low staffed right now, so I won't be able to step away. Is there any way we could do the week after that by chance? I know that's the week of.
19th? Okay, Ms. Gilmore?
I'm not trying to be difficult. I have a trial that week too. I could, is the court open on the 26th? I don't know. Or 1 week, frankly, let's see.
Or
I'm gonna be,
on the 26th.
okay, I could do the 26th, or honestly, if he could get it filed quickly, I could also do the 28th, which is next week. I know that it's difficult with the Thanksgiving holiday, but I already have the materials. If I need to file a quick declaration, I can.
Yeah, Mr. Lopez, what do you think about that? Rather than maybe going into January, if you can get those documents filed with the court today or tomorrow and just send a copy to Ms. Gilmore, would you be able to do that, do you think? Looks like the mute's on. Now it's off. Now it's on. Now it's off.
Yes, and would I still have to send it as well?
Oh, it's a
Would I
little
still send it to the court as well, or?
Definitely, definitely get it to the court. And then if it's the same document, the best course to do is to file with the court and then send a copy of the exact documents to Ms. Gilmore, just to make sure there's no confusion.
Oh, all right.
So if you're able to do that, would you be able to do that today or tomorrow?
Yes.
Okay. That would be perfect. If you can do that, then we could have the hearing on the 28th of November. And if that's
Okay.
agreeable to you, the 28th, that sounds like it's good for Ms. Gilmore. Would the 28th work for you, Mr. Lopez?
Yes.
Okay, great. So get those three documents that you had mentioned, get those to the court, file those with the court, and send a copy to Ms. Gilmore, and then we will set this over to the 28th of November at 9 a.m. and we can fully hear the arguments and be well informed.
Thank you, Your Honor.
All right, very good. Appreciate that. So we'll see everybody next week. Thank you.
Then I've got two more left here. I've got Lopez and Friend.
That's my concern, Your Honor.
This is a little, I was trying to sort this out. It looks like Judge Evans had heard this.
Your Honor, he did, and he set this over 1 week to allow Mr. Lopez the opportunity to file his reply. From Odyssey, it doesn't look like that occurred. We did provide a supplemental declaration based on some of the comments that were made at the last hearing.
Mr. Lopez, present.
Yes, Your Honor. I wasn't able to send those out, unfortunately.
All right. Well, when I reviewed through this, again, it wasn't real clear. It looked like, I'm not sure what Judge Evans was looking for. I looked through the motion and looked through the response. I don't know if anybody's planning on filing anything additional, but I guess I can proceed on what I have.
Yes, I'd prefer that, Your Honor. This is our third hearing. I don't think it necessarily needs to be in front of Judge Evans. We argued a little bit, and it ultimately just resulted in a set over today.
All right. So, Mr. Lopez, this was your motion. Did you have any comments you wanted to make in support of that?
Well, unfortunately my exhibits weren't sent out, but as long as you have my response, I'm totally okay with handling this matter today.
Okay. So do you have any comments you'd like to make in support of your motion? You're the one requesting this, so.
So basically, this is my second time finding Juanita in contempt. Our parenting plan is pretty basic. She is not following it at all when it comes to me being on having full access to doctors, his bank account. I call these places and they tell me that I have no right, like they can't release any information to me.
Well,
My
I
parents,
objected to that information wasn't contained within his.
So you don't have that in a declaration, sir, and it would be hearsay from a statement like that.
in my response or my exhibits, uh, I have a response from the bank from Red Canoe where my son's account is, and it says that I have no
Again, I have
access
to object. This is the information that he was supposed to file and didn't.
I don't have those exhibits, sir, so I
That's
can't
all right.
base this
So
on that issue.
basically what I'm here for today is to resolve the matter of not missing visitation with my son. I bring this motion in good faith. In our parenting plan, my son's mother is supposed to work with me because when we made it, the original pickup time was 3 p.m. and I had recently, well, I've been working 12-hour shifts for the past 6 months. So during that time, it was kind of 8 hours here, 12 hours here, but we've been working for a steady 6, 7 months, working 12 hours. So I work 6 to 6, and unfortunately, I don't have anybody to pick up my son. So that's why we made our parenting plan a little more flexible, where she's supposed to provide a third party or at least meet me halfway with given a good ahead of time notice. And Juanita does not at all meet me halfway in that matter. I've missed 3, 4 visits the past 2 months, 3 months, and really I'm just here today, Your Honor, to get help because I'm missing good quality time with my son, and my son has a sister, and she's full time in my life. My son is not full time. They have a great relationship, and I'm really missing the bonding experience with my son because of these games that Juanita is playing.
All right, we're working off of the December 15th of 2022 order, correct?
Yes, Your Honor.
Okay. Okay. Well, let me hear from respondent.
Yes, Your Honor, Megan Gilmore on behalf of respondent and non-new moving party, namely Juanita Friend. My client simply isn't in contention in this case of the final parenting plan entered in December. I think it's very important to know that I think this is the second or third contempt that father has brought since we finalized this case that has been denied. My client shouldn't be forced to defend her rightful actions. And again, nothing has been done willfully or intentionally in violation of the order. First, regarding decision making, as that was included within the motion, my client explains that she hasn't acted outside of the order. She applied for the child to be in preschool. She's on several wait lists. Once those providers become available, my client will confer with father. If the parties can't agree at that point, then we will bring it back before the court, as that's the rightful remedy. My client currently is on maternity leave and is providing education for the child while she's on leave. This child's meeting milestones. So frankly, there's just simply no contempt here, as there's been no action. The child is school age, will likely go to the school district in which my client is located, as she's the primary parent. But again, that's something that we will have to deal with down the line and come to an agreement or go before the court. So there's no contempt regarding decision making. I think that the larger issue is, yes, what father has mentioned within his dissertation of the contempt is the fact regarding visitation. My client continually is willing to provide the child on Fridays at 3 p.m. However, father is wanting my client to constantly modify and work outside of the order. My client is willing to do so, but up to a point. She has an infant, she lives in Lewis County, and she shouldn't be constantly forced to modify the parenting plan on a weekly basis. I think that the parenting plan really contemplates this, and father was represented at the time this final parenting plan was entered. And if the court looks to this was drafted by father's attorney. If you go to the transportation language, it specifically contemplates that father does have a rotating work schedule and may not be available at 6 p.m., but it does carve out that he should be providing third-party transportation. We were last before the court on contempt. The court made it specifically that his father or his girlfriend can be available. As explained within my client's declaration and not refuted with any materials, father's living girlfriend, who he does have a child with, is in this, i.e. in a serious relation with, does not work. So she is available, but father's refusing to do the exchanges and wants to do it at 6 o'clock rather than 3 o'clock. As explained within my client's declaration on September 8th, she went to YMCA at 3 o'clock. She waited a substantial period of time. Father didn't come. The transportation language specifically says that the child shall be picked up and returned at designated times. My client, again, shouldn't be in a weekly situation where she's fighting with father. If you look to the text messages, not only is he asking to modify the schedule, but he's frankly being extremely nasty to my client and threatening her on a weekly basis. So he brings this action with unclean hands by not only violating the parenting plan regarding the provisions, but then frankly bringing contempt for language that's simply not in the order. There's no requirement that my client is working with him on a daily basis. She testifies that she frankly has, but on the September 8th date, she couldn't. So we asked the court to deny the contempt regarding visitation. My client provides information within our supplemental materials that the father does have access to all the information regarding the tribal. She not only has signed multiple releases, but we've now filed those releases, so he has access to this. We're simply asking for direction of the court that my client doesn't have to continue to go back before the court on orders to show cause of language that simply isn't in the parenting plan. Father needs to be picking the child up at Friday at 3 p.m. for his normal exchange. And again, if he's not available, there is remedies within his parenting plan, again, that was drafted by his attorney.
All right. One question, I guess, and I didn't hear a response on that. It was in the motion having to do with a bank account question.
So and that was something that we addressed, that we did talk about a little bit with Judge Evans, excuse me, sorry, Aaron. There is a section under decision making that mother is to sign any documentation necessary so father can have access to the Cowlitz Indian tribe information. First, father is the tribal member. So my client doesn't believe that she could even deny this access, but once we realized that he was arguing access rather than the bank account at the last hearing, my client provided the supplemental materials and the release of information that shows that father has ability to get access to any information from the tribe.
Well, the question was raised something about a bank account. That's what I'm trying to understand.
Your
Yeah,
Honor,
and
I'm supposed to have full access to the bank account, and I do not. Because I am the tribal member of my son, but she is the full custodian parent. So basically, she's able to make it to who calls and gets release of information. I can't get any information from my son from my own tribe. And Your Honor, this is my tribe is full of all the employees is all my family, is all family, blood related. And they tell me that that Juanita friend had specifically called and said that I nor my
Okay,
Okay,
well,
well, sir, I don't have a declaration from those folks, so
That's
those
all
are
right.
all hearsay statement. My question has to do with the bank account. It's got nothing to do with the tribe.
So
Unless it's,
basically, Juanita gives me statements of the bank account, but I'm not able to call. I'm not
okay, well,
able to.
let me ask, where in the parenting plan does it talk about the bank account? That's what I'm trying to find.
Your Honor, I'm at work right now, so I'm sorry. I don't have my parenting plan in front of me.
Is there a section that has to do with bank account specifically?
It says release. I'm not sure where, but it's somewhere in there. It says release of information. That I'm subject to all information.
parenting plan contemplates that my client is supposed to sign any releases for the tribe. It requires her to continue to deposit the tribal funds into the bank account. There's no language that requires him to be on the account. That's basically what he's saying. I believe that's his argument.
Okay, because when I looked at the parenting plan, I didn't see any language that would put you on as a joint owner on the bank account. So, well, sir, let me hear from your response to that.
Well, to start it off, like I said, I bring this motion in good faith. I do not harass Juanita Friend at all. Our conversation is directly through the parenting app. I do get frustrated because this is an ongoing thing for 3 years now, and it's very frustrating because there's two sides to this. Um, I tell Juanita every time before Friday at the beginning of the week, hey, I'm working 12 hours again this whole week. I'm still working 12-hour shifts. I'm not able to make 3 p.m. None of my family will come for third party to pick up my son just due to the fact that there's been too many allegations. There's too much drama. My family will not involve themselves at all to pick up my son, but they are involved once I have my son. And to be honest, it's no one else's responsibility to pick up my son but my own. My girlfriend doesn't work, that's correct, but she's a full-time mother of our 1-year-old daughter. She's 13 months old and she goes to college full time. And that is also not her responsibility to pick up my son, but my own. And we are limited to one car right now. And the car is being driven by me to and from work. So I have no one to pick up my son on those Fridays. So I try to give a reasonable notice at the beginning of the week and say, hey, I will not be there. No one will be there at 3. I also ask her, hey, would you mind dropping him off at my house to my girlfriend? And she denies it. And she purposely goes to the YMCA where our pickup and drop off is, just to deliver her end of the the deal, saying that she showed up, that no one showed up. But Your Honor, she's doing that. I don't know why, because she's quite frankly wasting her own time doing that when I'm telling her, hey, no one's going to be there. Here are the options. Can you meet me after work at 6 when I'm off? Or can you drop my son off? I work full time, Your Honor. I can't leave my job. I don't even have breaks on my job. Like, I work, work, work. And it's like I said, it's just no one's responsibility. It's my responsibility to pick up my son. I don't harass Juanita. I'm quite frankly very much done with communicating with her. I just want a simple pick up and drop off is all I want. I don't feel I need to pay any attorney fees today. I brought this motion self-represented because it is a simple matter. I speak for myself. I, like I said, I bring this in good faith, Your Honor. That's all I have to say.
Your Honor, if I may, real quick.
Sure.
The transportation language specifically says that Longview YMCA is supposed to be the exchange location, simply because under section 14, there's restraints because father didn't want my client coming to the home. So that's the basis for YMCA. I just wanted to provide that clarification.
Right. Well, in looking through your parenting plan and looking through the different declarations that are filed, it looks like there's been releases of information. There may be some other things going on, but I don't have that information in front of me, so I'm not going to make a finding of contempt on the release of information issue. The bank account, there's no language that I can find in the parenting plan that requires the father to be a joint owner or be listed on the bank account. And it sounds like, I mean, there was a copy of, or a snapshot of a statement that was sent that would seem to comply with the sharing of information. The transportation issue is, and these are always challenging when people have so you set up these very specific parenting plans, and then circumstances change because the court is essentially stuck with enforcing the document that's in front of me, the actual listing of dimes and dates and places and that sort of thing. If the two of you agree to something in writing or through the parenting app that says you're going to do something else specifically, and then that's not followed through, and I have evidence of that, then I would maybe have grounds for contempt. But there's no requirement that there be a change in any of this unless you come back to court and get an actual order that changes the parenting plan. So, and you had indicated yourself, sir, that it's up to you to pick the child up or make arrangements to pick the child up. It sounds like at the last hearing there was some additional folks that were specifically approved. When I look at your parenting plan, it talks about child can be picked up by third parties. By your designee, it doesn't specifically other than a restriction on Candida Sanchez, it doesn't look like there's a restriction on who does that. Well, I guess there is. There's a section here that talks about a designee who's known to them and the other parent. But it seems to me if you may need to locate somebody else under your parenting plan to do the transportation unless there's an agreement to do it at a time when you're not working. So absent an agreement that's been violated or a specific violation of the parenting plan, I don't have a basis to find contempt. So I'm not going to do that. So, I mean, your options at this point, sir, are to either come to some agreement and have that in writing or to come back to court to modify this based on your job situation, which very well may be sufficient to look at some minor modifications at times, but I can't find contempt based on what I have in front of me. So I'm going to decline your motion.
Does your honor want to enter a bench order? Do you want me to prepare that order? What would you prefer?
I have an order, but it's not the one I would use. So this is a proposal that he'd provided, which has got all the findings in it. But if I do a bench order, it's just going to be the motion's denied at this point.
I prefer, I'll just prepare it just so that we have some clear language regarding the bank account, so we don't have ongoing issues with that. Is the court making an order on fees? I'm looking at my client statement. She's paid quite a bit.
Well, at this juncture, I'm going to order 500 in fees, not 1,000.
Okay.
Again, this is what you're going to need to do, sir. Is you may need to get some legal advice on how to address this so you can get this changed so it works with your schedule. But bringing contempt on something that is not in contempt is problematic for the court. So, as far as presentation, if it's agreed, just go ahead and submit it ex parte. If it's not, pretty much I can put it on for maybe the 8th at 8:45, which is a week from Friday.
I can do that. I just want to let the court know that I will be in Clark, but I should be able to balance both.
Okay. I mean, you can note it up if you can't agree too. It's up to you.
I prefer to just put it on the calendar so you don't have to worry about it. Let's do the 8th and then I will figure it all out.
Okay. So, Mr. Lopez, she's going to prepare up an order from today, send it to you for your approval. If it looks correct, you can sign it or let her know that you're in agreement with that. If you're not, then show up at 8 o'clock via Zoom on my 8:45 a.m. presentation docket. Okay?
All right, thank you.
You're welcome.